Good morning, everyone. You are welcome to your program, our program for today. On the program of Know Your Rights Under the Law, translated in Yoruba language as Mo Ẹ̀tọ́ Rẹ Lábẹ́ Òfin. My name is Abdullahi Adebayo Abdurrauf. Together with me today is my learning friend from the same faculty of law. Uh, my learning friend, he will mention his name when the time comes. But before I invite him to start the introduction and do the justification on the topic that we are here to discuss today, we have to discuss something about medical malpractice today, and we shall be discussing the the liabilities and the remedies that are available for whoever has suffered any injury from the liability of anything that may occur under medical malpractice. Please, can you please mention your name to the audience? They want to hear from you, sir.
Good morning, everyone. I greet you all, and I welcome you all back to the program. My name is Ridwanullah Solahudeen Olalekan. I'm a student at the Faculty of Law, Bayero University, Kano.
Okay, thank you. Today, as I've said earlier, medical malpractice. Whenever we're talking about medical malpractice under medical context, it may mean some other things in this aspect and some other things in that aspect. But under the prefect of Nigeria law, what can you explain to us that medical malpractice is under the prefect of Nigeria law?
Before I go deeply into what medical malpractice is, in a simple term, we say medical malpractice is any act or omission done or committed by a medical practitioner which results into an injury on a patient. In a deeper sense,
Okay.
The principal law governing the conduct of medical practice in Nigeria is what we refer to as Medical and Dental Practitioners Act 2004. This act established an agency we call by name Medical and Dental Council of Nigeria. The Medical and Dental Council of Nigeria provided for the registration of medical practitioners. This same agency, in its statutory duty, established or made provision for some laws which are guiding principles that are to be abide by, all that a medical practitioner must abide by when carrying out medical practice. They call this Code of Medical Ethics 2008. Anything done by a medical practitioner which contravenes the provision of this Code of Medical Ethics is referred to as medical malpractice.
If I want to take it from where you started, you said any act or omission that is done by any medical practitioner in the course of his work, that is when medical malpractice occurs. And further, you also explain that whenever in order not to make this medical malpractice of a thing to be a narrow thing, it is only what has been expressly provided in the medical and dental professional acts and maybe some code of ethics of the medical ethics. So it is everything that has been laid down upon in this ethics and acts that whenever any medical practitioner contravenes any of the provisions, that is when medical malpractice occurs. If I understand you very well, is
Yes,
that what you
are very correct.
mean?
You're very correct.
Okay, thank you very much for this enlightenment. I'm very grateful. Now, I think with what you have just said now, you have been able to do some kind of justification on the meaning that medical malpractice have. But we can't just say that medical malpractice is this and that without having some example that we may also be referenced to. So are there some examples that you can give to us under this thing that will make us to be able to relate with this medical malpractice, so that every time that we see something of a such nature, we will outrightly recognize that this is exactly what they are called medical malpractice, and by then we will be able to be aware of it, and at the same time able to get ourselves against it. Please take the mic.
Thank you very much. Generally, medical malpractice is divided into two.
Okay.
1, negligence or omission. 2, act. We have instances of this. An instance could be the failure of a doctor to attend to a patient promptly, which is required of him. That's one. Another example is failure to administer the correct drug. Failure to administer the correct drug for a correctly diagnosed patient. For instance, you diagnose someone of malaria. You went ahead to recommend what do we call it? Typhoid medicines for him. That is a medical malpractice. Another instance is a condition may warrant that a patient will have one of his limbs cut. By the time you take the person or you transfer the patient to the theater, out of negligence, you went ahead to cut the wrong limb. That's a medical negligence, or that's a medical malpractice too. Another one is failure to refer a patient for a better treatment, provided that your own hospital is unable to take care of the person or to handle the situation at hand. So it is expected of you to make immediate transfer of such patients to the right and capable hospital. So those are some of the examples.
Exactly what you're saying now. It happens sometimes, when a patient goes to maybe an hospital that may be in the neighborhood. So whenever they see that this thing is beyond their power or beyond their equipment or anything that they know that they can provide any service for, they will immediately transfer it. So what you are telling me in this circumstance is that whenever such a medical practitioner has detected that this thing is beyond his power, and he still refused to transfer such a patient to the place that to a hair. So in this kind of situation, medical malpractice has occurred.
Yes.
Okay. Those of you that you are just joining us, we are treating a topic today. The topic that we're treating is medical malpractice, the liabilities and the remedies. Please continue to follow us. Now, are there any other instances? Maybe are there any other examples that you can bring under this medical malpractice of a thing?
Okay. Another instance is failure to seek consent before administering anything on them. For instance, out of your medical diagnosis, you realize that this patient actually need to undergo a cesarean section. So it is expected of you legally to obtain the consent of that particular patient before going ahead to operate the person. Another one is failure to give the right advice to a patient regarding the possible consequence or consequences of a particular treatment. Now, there are some treatments that when you administer it on a person, it is possible that it may lead to non-functioning or malfunctioning of some parts of the person's body. So it is expected of you as a medical practitioner to advise the person. For instance, as a patient, someone approaches you for abortion. So you are expected to enlighten the person, even if you don't,
on the kind of risk that sort of being incurred in the process of that.
Tell them the risks involved. Okay, this thing is 50-50. Like if you conduct it, it is possible that the person survives, and it is
possible that
the person dies out of the process. So it is expected of you to inform the person of the dangers involved in that particular treatment.
So whenever a doctor fails to inform his patient of the risk that may occur in the process of that medical administering, in such a circumstance, medical malpractice has occurred, yes or no?
Yes.
Yes. Okay. You talk about consent too.
Yes.
So before a doctor does anything on a patient, he must firstly seek the consent of that patient. Yes or no? Especially in the please give me an
instance. Let me give you an instance. Okay. There is this case that I read some time ago. So the patient approached the doctor that he observed some kind of pain in around his scrotum. So
his scrotum.
Yes.
Okay.
They said they needed an operation. They need to carry out an operation. During the course of the operation, as the operation is ongoing, they treated that area. But the doctor observed that there is another risk in another part of the person's body. But this one, if operated, will affect the function of the patient's manhood. The doctor, without seeking the consent of the patient, went ahead to conduct the operation. The operation was successful, but of course, the consequence
affected
the person's manhood. Yes, that
fundamental human right.
That one proceeded to the court. And the court held in his favor. They said the medical practitioner was expected to the patient's consent before going ahead with the operation, but he did not.
You know, I have,
even though what he did there was for good with good intention, but it is expected of him as a matter of ethics to inform the patient,
to firstly ask for the patient's consent before it goes further. You know, some of the times, you know, people usually go to hospital to deliver of a baby, and when there is complication, they refer them to not even other hospitals in some instance, but cesarean session operation.
Yes.
You know, before they carry that operation, most of the times they will firstly bring out a document that if maybe the husband or anybody that knows that is closely related with the closely related with the person that wants to deliver his baby will sign. And you know, I think this also is a kind of seeking consent of the patient. You know, in this kind of situation, even the patient may not even know where he is again, because
there is limitation, there is exception.
Okay,
but that's true. There is this popular instance. It is a locus classicus case. The fact of the case is that the patient needs blood. They have to do blood transfusion. Yes. Okay. But the creed of the patient, the religion of the patient, the religion of the patient does not allow the patient to undergo that kind of process. If the doctor, as a matter of urgency, had to do the blood transfusion, and he did it, so the operation was successful. But at the end, the patient went ahead to challenge the doctor.
The conduct of the doctor in court.
In court.
Okay.
But the court ended in favor of the doctor. Do you know why? Because evidence proves that if the doctor had, think of seeking the consent of the patient before performing the blood transfusion, the patient will die. They will lose the patient in the process. So it was a matter of urgency. It is in between life and death. So the doctor was left with no choice
option than to
do it.
So in this circumstance, when the doctor does not seek the consent of the patient, it can't be said that because the doctor has committed
medical malpractice. No,
not in that instance. Okay. That means that even consent have exception.
Yes,
to some extent. Okay. Yeah, I'm very grateful for what you just tell us now. In fact, I'm very grateful. Well, please let's go further. As we are be able to establish medical negligence and some instances that please, are there any liabilities that may incur in maybe as a result of medical malpractice? Are there any liabilities that may be incurred maybe by the patient or any member of the family that is closely related with the patient. Are there?
Hello.
Yeah.
I want to quickly chip in before you move on to the next topic.
Okay.
It's some kind of a question about the consent. You are discussing consent.
Okay.
Hello, can you still hear me?
Okay, of course we can hear you.
Very clear.
Okay, so now in a situation whereby a patient is being operated, and just like the one you mentioned earlier, that there is a case whereby a doctor went ahead to give blood to someone whose religion is against receiving blood from another person or something like that, if I got it right. Hello, are you with me?
Yes. Yes.
So now let's not use this instance again, that a patient that is being operated, it cannot give consent. Is there is there any how do I put it? Is there any rules or law that gives somebody else a right to give consent on behalf of the patient? Do you understand the question?
Yes,
of course.
So is there a rule that give somebody else right to give consent on behalf of the patient?
Are you done?
Yes. That's just it for now.
Okay. So there is something we call next of kin.
Okay.
There is something we call next of kin. The primary assignment, the primary duty, the primary responsibility of a next of kin is to sue on behalf of the patient or on behalf of someone. So if you
do what?
The primary duty of a next of kin is to sue on behalf of the person for whom is serving as the next of kin.
All right.
So in that kind of situation, the doctor will have to call the next of kin to come and sign on behalf of the patient, provided that the patient is not in a good condition to make the signation.
Okay.
Yes, that means that what you're just trying to say is that one of the benefits of making the person is in next of kin is that whenever such a person is in a critical condition that needs his consent and is not conscious to give the consent at that, so the next of kin can come in and do whatever that is necessary. Please, are you satisfied with the answer for the question so that we can proceed?
I'm partially satisfied, but one more question before I go.
Please, can you please ask this question when we go to question and answer segment?
All right, okay, all right. Proceed then. You can proceed.
Okay, sir. Thanks to you, so now we are moving to the liabilities that may incur after there is medical malpractice. What are those liabilities that may incur if there are?
There are three ways. Of making, or how do I put it? There are three ways that a patient can take to enforce his rights if that kind of patient falls victim of a medical malpractice. Okay. The first way is to make use of the criminal law. Making use of the criminal law will give the courts the right to enforce the patient's rights on his behalf. An instance is the provision of section 343 sub 1e of the criminal code. It goes thus: any person who in the manner so rash or negligent as to endanger human life or to be likely to cause harm to any other person, giving medical or surgical treatment to any person whom he has undertaken to treat, is guilty of misdemeanor and is liable to imprisonment for 1 year. That is under the criminal code or the criminal law. Another way of enforcing one's rights as a victim of medical malpractice is to sue under the civil law. If one sues under the civil law and the claim is established before the courts, of course, the person or the victim will be entitled to damages, which will be awarded to him against the accused by the courts. But before this can happen, there are 3 conditions that has to be fulfilled, that has to be met before such damages can be executed. Number 1 is that the patient or the claimant has to prove that the doctor owes a duty of care to the patient. Number 2, if we can prove this, is that we have to prove that the doctor actually committed a medical malpractice, for instance, negligence. After that, we have to prove, to establish before the court that it is that negligent act of the doctor that resulted in the injury sustained by the patient. If any of these conditions is not met, the claim cannot be upheld. If this claim is upheld or is proved before the court, definitely a certain amount of money in damages will be awarded to the patient. The third way is to go by the provision of the Medical and Dental Practitioners Act 2004. If you want to do this, the first thing is to file a complaint to the Medical and Dental Practitioners Panel. This panel is saddled with the responsibility of admitting complaints or allegations leveled against a medical practitioner. When they, after due consideration, they find the claim to be meritorious, they will have to further file it to the Medical and Dental Practitioners Tribunal. It is this court that will now do 3 things against the doctor. The first thing,
or either of the
3. Okay. Yes, any of the 3, not all.
Okay.
Any of the 3. Number 1 is to strike the person's name off the register of the medical and dental practitioners. That's 1. 2, they can suspend the medical practitioner's license for a period not more than 6 months. The third thing they can do is to admonish the doctor, that is by scolding him, giving him a very serious warning.
So that he won't do it again. Okay. I'm very grateful for the justification that you just did on the topic now. So summarily, you say when you were giving us this infallible lecture, you made mention of 3 things that may likely cause medical malpractice to occur, and some remedies that may come. And you know, when you are trying to explain, you made mention of 3 things that must be proved, that must be established before medical malpractice can be said to have been to have taken place. The first thing, if I can remember, is that there is a relationship between the doctor and the patient that brings about the duty of care. Yes. So from the doctor to the patient. That is the first one, right? Yes. And the second one is that the duty that is the duty that is binded on the doctor has been breached. Yes. That means that the doctor did not provide the care that he should have provided because of his profession to that patient. That is number 2, right? And the third one is that the patient has actually sustained an injury directly caused from the misconduct of the doctor. Yes. So when the 3 things have been proved, that means that the case of medical malpractice has been established effectively. Yes or no? Yes. Okay. And you also talk about the remedies that may be available for a patient, for the victim of medical malpractice. You talk about going under civil procedure law,
yes,
according to section 3.3 of the Criminal Code Act, which may result to 1 year imprisonment. And such a person may also go to court on his own self to go and enforce his law
an action
under civil
law. That one will amount to damages.
Yes,
okay, against the doctor.
And the third one is that such a patient may report such a doctor or medical practitioner, medical or dental practitioner to medical and dental practitioner commission.
Something I think we need to clarify there also. You see, when a doctor commits a medical malpractice, okay, I think it is important to let our people know that sometimes it may not only be the doctor that will bear the consequence. That is where the issue of vicarious liability comes.
Vicarious liability.
The hospital may be liable too. There is this case, the case of Ibokwe versus UCH management. So the court said that the hospital is liable for medical malpractice acts committed by their employee during the course of his employment. So it may not only be the doctor
that will be liable.
Yes, the entire hospital will bear the brunt.
We're talking about vicarious liability for the sake of we law students. Vicarious liability is a kind of liability that makes the boss to be liable for the misconduct of his employee. Let's say, for instance, Mr. A employs Mr. B, and Mr. B did some misconduct in the process of in the course of his employment. The patient that suffers the injury of Mr. B may sue the company of Mr. A and have Mr. A liable for the misconduct of his employee. So that also occurs under medical malpractice also. So it is not only the doctor that the patient may hold responsible, even the hospital itself may also be held responsible for the conduct of malpractice. Okay, thank you very much. So now let me buttress what I was trying to say summarily. So now when such a patient has now reported this medical practitioner to appropriate quarters, the medical and dental practitioner panel. Yes. The remedy that will come from there is 3. Yes. The first one is such a patient, his name will be struck out of the register. Yes. That means that he won't be doctor for the rest of his life.
For the rest of his life. So he has ended his career.
The career will be ended. And the second one is that he may be suspended from work.
Yes, for 6 months. Not more than 6 months.
Not more than 6 months.
Yes.
And the third one is that
to admonish the doctor.
Yes. And the third one is that they just give him serious warning.
Yes, that's a kind of
admonition, so that the thing will not occur again. It is now left to the victim to go through any of the ways that are available.
We go for damages.
We go for
if you want him to go to prison.
You go under criminal law.
Yes. If you want him to be we don't want him to practice again.
And regular doctor,
go through the panel. Go through the panel.
Okay. I'm very grateful for the justification that you have just did now. By the special grace of Allah, may your knowledge have been increased. Your knowledge have been increased, and may it be beneficial for you, not only you, your family, the entire Nigeria and the world at large. The world at large. Now we shall be moving on to the question and answer segment. The question and answer segment. There has been some questions that have been posed to us under the comment section. I think we should just stroll through it, pending the time that we shall be accommodating another questions. The first question here was the one that was asked by, I think, was it a question or a comment? Let me check. I couldn't check very well then. So, okay, before we even go to the question and answer segment, let's acknowledge those that have commented on the program so far. We have seen you, Chime Chupuwa Bioziem. Please, I'm very sorry if I can't pronounce your name very well. You are very much acknowledged. Ridwanullah Sodiq, you comment with respect. We respect you too. We are very much grateful. Prince of Paris, Michael. That is fabulous comrade. He likes fabulous very well. He wants to join military next year. Wow. He has been texting me that he wants to join the military. Yeah, where you'll be going to hit is Agbado and Cassava. Adeyinka, no, Umeimat Hassan, he commented great job. He's our colleague at the Faculty of Law. We recognize you, we acknowledge you. We are very grateful that you find us worthy to watch our program. We are very grateful. Adeyinka Olasokanmi, Kasama say that is our engineer. He also commented on the program. Very impressive. We are very grateful. Masood Abib, well done, sir. May thy Lord increase you in knowledge and understanding. Really enjoy the program. We are very grateful that you enjoy the program. We are very grateful that you watch the program. We are very grateful. He is a pharmacist in training. Yusuf Ahmad, what does medical malpractice mean in Nigerian law, and what are the elements of medical malpractice? Because I'm not hearing the language. We have done that already. Maybe we made this comment when we were 35 minutes when we are under the Yoruba segment. So again, well done. Aminu Kabir, great job. We acknowledge you, and we see Adekunle Yusuf. He commented with love. We are very grateful to you, sir. Afolabi Samsudeen, love this. Yes, we love you too, that you love it. We love you. Adekunle Yusuf also commented again. Rahim Zakiruddin, love this. Yes, we also love you too. Abdurrahman Alatisi Ajani Akewi, he commented in Yoruba language. Ekwise Amofin, which can be interpreted by us. Well done, lawyer. Please, we are not lawyers. We are we are law students. Please don't address us as lawyers. That will be amount to impersonation if you address us. Even though we can only be called lawyer within the comfort of the faculty of law in our school. So you know, we were doing called to the bar last year. On the night of last year, we were I think on the 13th of last year, we were called to the bar. We are baristas and solicitors. November. No, December. We are baristas and solicitors of the Bayero University Students Union Court. Only. Outside that, we are not lawyers. We are not lawyers. We are just law students. Immediately we exit the school entrance. We are no more lawyers. We are students. So thank you very much. So near boy, Abu Abdullah Bais, he commented with love. We love you too. Aderinto Rashidat, keep up the good work. And you are very grateful for the feedback and encouragement. We are very grateful. Adeyema Oluwasegun, love this. Aku Ojuma Oluwa Toyin Dada, Ekaro Aku Isimi Oni, adúpẹ́ lọ́wọ́ gbogbo àwọn tí wọ́n ti fi àtẹ̀jíṣẹ́ ránṣẹ́ sí wa. Tí kò bá sí ìbéèrè ní àtọ̀dọ̀ ẹ̀yin aráalé, a gbọ́ pé ẹnjìníà fẹ́ béèrè àwọn ìbéèrè kan ní ẹ̀ẹ̀kan, ká mọ̀ fi èyí ò lè ká mọ̀ fi káàdì rẹ̀ lẹ̀. So if there is no question from those that are watching us now, I think our engineer has one or two questions that he wants to ask us. Based on the discussion that we just made now. Please, engineer, can you please come in to ask the question further? It's like the engineer wants to cross-examine us. Because I think the justification that you have just done on the question, I think it should be sufficient. But well, our engineer is now thinking like a lawyer, because no matter what you tell our engineer, he will want to ask more questions to know the certainty and the credence of that thing. And I like the confidence of our engineer, the curiosity. I like it very much. I like it very much. Engineer, please, do you have any other question that you want to ask us before we call it a day for this week?
I'm so sorry, I was indisposed before. But